All please rise.
Thank you for standing. Please be seated. Good morning. We are convened in the Iowa District Court for Sac County. This is in the matter of State of Iowa plaintiff versus Brett Edward Pryor, case FECR 012649. Today's the date set for further hearing, which the court understands is a hearing regarding a plea agreement reached by the parties. Folks, my name is Jim McGlynn. I'm a district court judge assigned to hear this case today. We are reporting the proceedings. As you can see, I'd like to have everyone identified for the record, and we'll start with the county attorney and just go down the council table.
Ben Smith, County Attorney for Sac County.
Mr. Pryor. And you are the defendant in this case, correct?
Correct.
Charles Schulte, attorney for the district.
Thank you, folks. And am I correct? This is a case where a plea agreement has been reached?
It is, Your Honor.
And county attorney, if you would summarize what that plea agreement would be.
Certainly, Your Honor. Defendant was charged October 13 of 2014 with 3 counts by a trial information filed in this matter, FECR 012649, count 1, manufacturing, delivering, possessing with intent to manufacture or deliver marijuana, class B. Count 2, manufacturing, deliver, or possess with intent to manufacture or deliver LSD, class B. And then the third count just mirrors count 1, and is based upon a different event or incident occurring on or around the same time. Anyway, in consideration of defendant pleading guilty to count 1, the state would dismiss counts 2 and 3. Further, the state would, the parties have agreed to open sentencing on count 1. And I think that's it, Judge.
And this is possession of
marijuana, Your Honor, class D in violation of Iowa Code section 124.401 1D.
and the other 2 counts will be dismissed.
Yes, Your Honor.
And Mr. Schulte, on behalf of the defendant, is that your understanding of the plea agreement?
It is, Your Honor.
Well, Mr. Pryor, the attorneys tell me that they've reached this agreement. Is this something that you are willing to do?
Yes.
All right. Before I can even let you plead guilty, though, I need to go over quite a few things with you because I need to make sure that you understand what you're doing. I need to make sure that you're doing this of your own free will, that you understand that you have quite a few rights that protect you here in the courtroom, and I need to make sure that you really did do something illegal to bring you here. As you go along, feel free to consult with your attorney. He is here to help you. And if you need to, we'll take a break so you can visit with him in private. If you don't understand what I'm saying, if you have any questions of me, let me know and I'll try to respond. Need to have you answer out loud. You can't just nod or shake your head. My court report is taking words, and so you can't take gestures down. So you have to, if you mean yes, say yes. If you mean no, say no. You just need to clearly understand what it is that you mean. All right? How old are you now, sir?
I'm 25.
And have you had enough time to visit with your attorney about these matters? Tell me what the extent of your education is.
I completed high school diploma.
And can you read and understand the English language?
Yes, sir.
Are you currently under the care of a doctor, a psychiatrist, a psychologist, anything like that?
No, sir.
Are you currently, and you sit here today, are you under the influence of any drug, alcohol, anything of
No.
Okay. Have you been hospitalized for any reason within the last 6 months?
No.
Do you have any other charges pending against you in this county or anywhere else?
No.
Are you currently under probation or parole for anything else?
Yes.
And what are you on probation for? Or is it parole?
Parole.
Parole.
technically, yeah. It's
It's a 10-year parole after a probation for, I believe it was, indecent contact with a minor.
Okay. And do you understand that among the consequences of your guilty plea is the fact that your parole could be revoked?
yes.
You understand that is not something that this court is going to be involved with?
Yes.
And so in addition to the consequences for your plea to this Class D felony charge, you understand you could be returned to prison on that indecent contact with a
Yes.
minor charge. You understand that?
Mm-hmm.
That's a yes?
Yes.
Anything else, probation, parole, anything else that's...
No, sir.
Now, I need to advise you that you have quite a few rights which protect you here in the courtroom. Those rights can be summarized by saying you have the right to have an attorney and you have the right to remain silent. When you got arrested, perhaps you were told by the arresting officer or some other officer, or perhaps you've been told this in your previous charges, or you've seen it on television or in a movie, but the Miranda rights are often read to the suspects in the case. And do you recall being given your Miranda rights in this case?
Yes, sir.
Right. And so you were told you have the right to have an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. And Mr. Schulte has been appointed to represent you, is that correct?
Yes, sir.
And are you satisfied with his services?
Yes.
So that's pretty straightforward, and he's going to remain with you throughout these proceedings. And as I told you before, if you need to visit with him at any time as we go along, let me know, and we'll take a break and you can visit with him in private. So that's a pretty straightforward deal. This right to remain silent is a lot more complicated. It includes an awful lot of different things. But what it comes down to is you don't have to plead guilty if you don't want to. You don't have to say anything at all about these charges unless you choose to do so. And if you would rather, you could have a trial. At that trial, you would be presumed to be innocent until the state convinces the jury beyond a reasonable doubt that you're guilty. Again, your attorney would be with you throughout that trial if that's what you chose to do. He would help in the selection of the jury. A panel of citizens would be brought into the courtroom, and then 12 people would be chosen to serve as your jury. And your attorney would help in the selection of that jury. Your attorney would help you by making statements and arguments to the jury, and statements and arguments to the court, and helping the court to come up with instructions for the jury. As the trial went on, your attorney would help with the cross-examination of witnesses. The state would have to bring witnesses in to testify under oath. If they're on the witness stand, each one of those witnesses would have to testify in front of you and tell their story. And so your lawyer would help you by asking questions. It's called cross-examination, to try to be sure that each witness is really telling the truth and not mistaken. You have the right to testify if you want. That's your choice completely. But you also have the right to remain silent. No one would make you testify. No one would hold it against you if you chose to remain silent. But your attorney would help you make that decision. And if you decided to plead guilty, if you decided to testify, he would help you present your testimony to the jury. If there was other evidence, other witnesses or physical evidence of any kind that you wanted presented to the jury, your lawyer could get court orders, subpoenas, to get that evidence before the jury. And as I said before, he would make arguments to the jury and help the court with the instructions to the jury. After listening to all of the evidence, the jury would either be convinced beyond a reasonable doubt, and they'd have to be unanimously convinced, all 12, not 11 to 1 or 10 to 2, all 12 would have to be convinced beyond a reasonable doubt of your guilt. If they were convinced, then you would be convicted. If they were not convinced unanimously, beyond a reasonable doubt of your guilt, the presumption of innocence remains and you're found not guilty. As I said, that's an awful lot to understand, but what I want you to come away with is the knowledge that you have these rights, and that you give most of those rights up when you plead guilty. Because if you plead guilty, there's not going to be a trial. This is it. You understand that?
Yes, sir.
There won't be any jury here. There won't be any witnesses on that witness stand. The way the case gets proved is that you have to give up your right to remain silent and actually tell me what it was that you did to bring you into the courtroom. You understand that?
Yes, sir.
And do you still want to plead guilty?
Yes, sir.
Okay. Now, you were originally charged with 3 counts. Count 1 and count 3, as the county attorney mentioned, are similar, they just involve different incidents, where it's alleged that you manufactured, delivered, or possessed with intent to manufacture or deliver marijuana in an amount less than 50 kilograms. Count 2 is a more serious offense. It's alleged that you manufactured, delivered, or possessed with intent to manufacture or deliver LSD. Count 1 and count 3 are Class D felonies. Class 2 is a Class B felony. What the state would have to prove, and it's count 1, not count 3, it's count 1 that the defendant's pleading guilty to.
Yes, Your Honor.
In count 1, what the state would have to prove is that you either manufactured, or you delivered, or you possessed with the intent to manufacture or deliver marijuana in a quantity less than 50 kilograms, that you did so willfully and knowingly. And the penalty for that, as a Class D felony, is not more than 5 years. And a fine of not more than $7,500, not less than $750. There are other consequences. You would lose your driver's license for 180 days. This is a felony. You would be required to provide a DNA sample. If a fine is imposed, there's a surcharge of 35%, which is added to the fine. So if a $1,000 fine is imposed upon you, another $350 surcharge is imposed. This would be subject to the $125 law enforcement initiative surcharge and the $10 DARE surcharges. Those 2 surcharges cannot be suspended. Are you a native-born person? That is the reason I ask that. If someone who is an illegal immigrant can be deported for conviction of something like this.
I am a native citizen.
You're a native citizen. So that is not a consequence you have to worry about. Those are the possible consequences. You could go to prison for up to 5 years. You could be fined up to $7,500 plus 35% surcharge. You'd be ordered to pay the DARE and law enforcement initiative surcharges. You would lose your license for the 180-day period. You would be required to provide the DNA sample. And then, as we discussed before, you are on parole. You risk the loss of your parole as a result of this. Do you understand all of that?
Yes, sir.
And are you still willing to plead guilty?
Yes, sir.
Has anyone made, and the plea agreement that I understand is that the state is dismissing count 2 and count 3. And it's an open recommendation. The state is not bound to recommend any particular sentence, but then at the same time, you and your attorney can urge the court to impose any kind of sentence that you think is fair. Is that your understanding of the plea agreement?
Yes, sir.
Has anyone made any other promise or any other prediction, or said or done anything at all to get you to plead guilty? Anything that I didn't hear about just right now in the courtroom today?
No, sir.
When the state filed these charges, the state filed what's called a trial information, and I made a copy of it. Did you get a copy of this document?
Yes, sir.
All right. And did you have an adequate opportunity to review that with Mr. Schulte?
Yes.
Okay. And also, at the time the state filed that trial information, the state filed what's called minutes of testimony. The state identified the witnesses it would call if this went to trial, and provided a summary of what each one of those witnesses would say if this went to trial. Did you also get a copy of the minutes of testimony?
Yes, sir.
And did you read that?
Yes.
And did you review that with your attorney?
Yes.
Okay. In deciding whether to accept your guilty plea, can the court rely upon those summaries of what, if this had gone to trial, what those witnesses would have said at trial? May I rely upon those?
Yes.
And having read those matters and discussed things with your attorney, are you aware of any legal or factual argument that you could or should make in this matter to get you out from under these charges?
No, sir.
Mr. Schulte, are you aware of any legal or factual argument other than a general denial that should be urged on behalf of your client?
No, Your Honor.
And I've told you what could happen, but you understand that it's ultimately going to be up to the sentencing court. I'm going to set a separate date for sentencing and order a pre-sentence investigation, which will be considered, and probably be some other judge other than me that makes the actual decision regarding the sentence in this case. You understand that?
Yes, sir.
And then it's actually going to be up to someone else to decide whether your parole should or should not be revoked. Do you understand that? So, if this went to trial, and I may have touched on this, what the state would have to prove, beyond a reasonable doubt, is that you knowingly and intentionally either manufactured, or you delivered, or you possessed, with the intent to manufacture or deliver, a quantity of marijuana less than 50 kilograms here in Sac County, Iowa. Do you understand what the state would have to prove?
Yes.
And you still wish to plead guilty?
Yes.
And is there any reason that the state knows of why I should not accept the defendant's plea at this point?
No, Your Honor.
Or Mr. Schulte, any reason you know of I should not accept the defendant's plea?
No, Your Honor.
Anything I have omitted that could affect the validity of his plea?
No, Your Honor.
No, Your Honor. Okay. Well then, Mr. Pryor, if it's still your wish to plead guilty, I need to have you tell me, in regard to count 1, what is it that you did on or about September 20, 2014, here in Sac County, to bring you into the court?
I got stopped with marijuana in my car, with the intent of selling it.
Okay. And it was less than 50 kilograms?
Yes.
And you admit, and that happened here in Sac County?
Yes.
And you admit that you possessed that marijuana with the intent to deliver it?
Yes.
Is the state satisfied as to the factual basis?
Yes, Your Honor.
Mr. Schulte, you're satisfied as to the factual basis?
Yes, Your Honor.
I also am satisfied as to the factual basis. I'm also satisfied, sir, that you are voluntarily entering your plea of guilty to this charge. I'm also satisfied that you understand your rights and that you understand the consequences of your guilty plea, both within this case and regarding the parole. So I will accept your guilty plea. I don't have my calendar in front of me, but the order will set forth the time and date of the sentencing. The defendant is out on pretrial release, is that correct?
Yes, Your Honor.
And those terms may continue pending the sentencing?
Yes, Your Honor.
Okay. I will order that a pre-sentence investigation be conducted. We need to cooperate with that. And as I said, the order will set forth the time and date of the sentencing, and will remain on pretrial release as previously ordered. Now, even though you just pled guilty, you still retain some rights. You have the right, if you wish, to attack this guilty plea. If for any reason you want to undo this guilty plea, if you think that I failed to explain something, if you think there's any problem whatsoever with this guilty plea proceeding, what you need to do is file what is called a motion in arrest of judgment. And that's an odd sounding term. What arrest of judgment means is to stop the sentencing. Now, the important thing is that if you're going to file that motion, you have to do it timely. It has to be filed no later than 45 days after today, but in any event, at least 5 days before the date set for sentencing. And if you don't timely file it, then you forever lose the right to file a motion in arrest of judgment and attack this guilty plea proceeding. Do you understand that?
Yes, sir.
And you can visit with your attorney further about those rights. Is there anything else I need to address for the state?
No, Your Honor.
Mr. Schulte, anything else?
No, Your Honor.
Okay. Mr. Pryor, do you have any questions?
No.
Okay. So I have accepted the guilty plea. We stand adjourned until the sentencing. That concludes the hearing.